understand everything. So read and understand everything. How many of you in here have ever bought something online and then click that little box that says, I've read these terms and conditions, but not actually read the terms and conditions? Yeah, me too. We've all done it. Why do you think it's important to read the terms and conditions before you click the box?
Because you don't really know what you're agreeing to.
Correct. So I've seen clients who've come to me and said, hey, I've had this credit card charge from this place, and I don't know, all I did was bought this CD for $1.99, and now I seem to be charged I've been charged £30 a month actually at this point for 10 months, and they won't give me a refund. This was one of those where actually a lawyer on the other end of the phone, you can just say, hi, I'm the lawyer for such and such, and they'd like a refund. Okay, yes, we'll give you a refund, of course you will, because they know that that's immoral. It feels immoral, and that's all about your values, but can they do it? If you've clicked to say you've read the terms and conditions, or you haven't ticked a box, now, I would say, I'll presuppose this, there are consumer rules and business rules. If you're signing something as a business, there are higher rules, if you're signing something as a consumer, then they have to be fairer terms than if you're signing something as a business. But as all of you are going to be signing as a business, it's important that you read and understand everything. So I want to just go through at this point some of the things that may not be understood in a contract. Some of those things that I remember I remember not understanding. In fact, probably for years, as a lawyer, I was like, why do we have this in here? So is that all right if I go through a couple of those terms? They're contractual terms, and it is a little bit dry, but it will help you to be able to, when you're reading through, at least skim the document first. Look out for some of these words. So the first one is indemnity. So an indemnity is a promise from you to them to pay them in the event that they suffer loss. So in order for you to limit your loss in your business, you don't want to be indemnifying anybody for anything, particularly if it's not something that you've done. So look through the contract and look for anything that says indemnity or promise to pay. The second one is limitation of liability. A limitation of liability clause, if you are the person providing the services, so for example, in my agreement to provide legal services, I will limit my loss to the amount that is paid to me in the last 3 months. You should be doing the same if you're providing a service. You should have a limitation of liability in your contracts, either if you're providing services or you're providing goods. And you want to limit that loss as much as possible. So, for example, I'm seeing more and more is we limit our liability for the last 3 months of money that has been received by us. So that's the sort of thing. Don't think that you're limiting your liability to the insurance that you have. I have seen contracts that have come to me saying, we don't know where this has come from. It's probably, I don't know if any of you have done this, but have you ever gone to your competitor's website and looked at the T's and C's and taken those T's and C's? Maybe not in this room. I can guarantee you it's standard practice. Someone's probably taken your T's and C's and you haven't even had them reviewed by a lawyer, and it's this constant people taking copies of things that aren't quite right. So you end up having, this actually happened to one of my clients, £1 million worth of liability for something like a £2,000 per year service that they were providing. That's ridiculous. That's disproportionate. You want to limit your loss and you want to limit it as much as possible. So limitation of liability. Make sure it's in there for what you do, for if you're providing any services, and make sure that if someone else is providing those services, that the loss within that, so if it says, for example, we'll limit your loss to the last 3 months paid, you need to work out whether that would be sufficient if you did lose something. Subcontractors, that's a good issue with the subcontracting, because if they're the ones performing the services and it's your client, and they screw up, and they have limited their liability, you need to make sure that you've limited your liability as well to the customer. So you need to make sure that you have an appropriate level that gives you enough enough bandwidth, if you like. The third one is law. Now, in your agreements, it will always say English law. Likely, but do check. Not UK law, because there is no such thing. It's the law of England and Wales. And make sure that it says the law of England and Wales and the courts within England. Oh, and by the way, I should probably tell you, a lot of this information is on our website, so you can go to the website, and there are lots of articles on this. So you can scribble away as much as you like to get the information down, but don't worry, it's not lost. It is on our website. So England and Wales should be the law. You will want to make sure that it says the exclusive jurisdiction of the English courts. Those are two things that are really important for your own contracts. Why? Because you don't want somebody who signed up to your agreement being able to take you to France and for you to have to pay, let's say it's a client in France, assume, you want having to pay a local lawyer, a translator, somebody who can understand the law in those countries. And so this takes me to my next point, and that is the law within other people's contracts. Have you ever read, when you've signed up to something online, the terms and conditions of something outside of the UK? Maybe not. Particularly if you go to the US. If you want to, if something happens to a service provided by somebody outside of the UK, then you will have to go to their country in order to instigate any proceedings against them. Now that might be fine in a regular context. You click onto Google, you're not really that bothered. If you're buying a $2.99 CD, then it might not be a problem. However, if you do have a relationship with somebody, and particularly when we're talking about licensing, when you start licensing abroad, you want to make sure that everybody, if there's an issue, they have to come back here to make sure, if there's an issue, then it's dealt with in the English courts. You want to go down the road, you don't want to have to jet off and pay travel and expenses and language costs for someone else. So check the language out and check the law of the jurisdiction as well. And then, well, this will take us on to the next bit, but basically with agreements, so read and understand everything. What I would do is read it, skim it, highlight any red flags. Talk to somebody else outside of the contract, whether it's a lawyer or just somebody who cares about your business, or whether you do well, and say, what do you think that this does? Also, ask the other side, because often they haven't had a contract, they haven't had somebody draft it. And so you want to make sure that you're both on the same page and that you're not signing up to something stupid that actually hurts you both.